In my last video, I covered the 5 reasons you likely do need probate in North Carolina. The good news is, oftentimes you can save a lot of time and money by avoiding probate altogether. My name's Ryan Smith. I'm a licensed real estate agent and certified probate expert here in New Hanover County, North Carolina. And today I'm going to share the 5 most common ways families can legally skip the probate process. Before we jump in, I always remind everybody I'm not an attorney and nothing I'm sharing today is legal advice. What I am giving you is educational information based on my experience of working with families through the probate process every day. What I do strongly recommend is that you have a conversation with an attorney, one that specializes in estate and specifically probate law. Even if it's just one conversation in the beginning, so you're certain that you're handling everything correctly from the start. There are some excellent attorneys right here in our area. If you'd like a recommendation, reach out. I'd be happy to connect you with them. All right, so let's talk about those 5 reasons you might not need probate. Reason number 1, the property was owned jointly. This is one of the most common ways people avoid probate, and it happens automatically with married couples. If property was owned by 2 people together and the paperwork specifically says that they own it with right of survivorship, then when one owner dies, the other owner automatically becomes the sole owner and there's no probate required. I'll give you a typical example. If your parents bought their house together 30 years ago, the deed says John Smith and Mary Smith, and it includes language like as tenants by the entirety or with right of survivorship. If your father passes away, your mother automatically becomes the sole owner of the house. She doesn't need to go through probate to do that. She just simply needs to file your father's death certificate with the Register of Deeds, and the property records will get updated to show that she's the sole owner. This works the same way with jointly owned bank accounts that have right of survivorship. When one account holder dies, the surviving account holder automatically gets full ownership. They just show the death certificate to the bank. All banks are a little different on how they handle it, but the bank updates the account to show one owner instead of 2. And the important thing to know is just having 2 names on a deed or a bank account doesn't automatically mean it has the survivorship feature. So the document has to specifically include the language with right of survivorship or as tenants by the entirety. If the deed or the account just has 2 names without the special language, you might still need probate. So if you're looking at a deed or bank account, check the exact wording and of course get some help from your attorney. Reason number 2, beneficiaries were named on everything. This is honestly one of the smartest and easiest ways to avoid probate, and I wish more people would take advantage of it. If your loved one properly named beneficiaries on all their accounts, those accounts will transfer directly to beneficiaries without any probate at all. A quick example would be life insurance policies. These always have a beneficiary. And as long as that person is still living, the insurance company just needs a death certificate in order to write a check directly to the beneficiary without probate needed. Retirement accounts like 401ks and IRAs, these also let you name a beneficiary. When the owner of that account passes, the money goes straight to whoever was named. Also, bank accounts can be set up as a POD, which stands for payable on death. You would just go to your bank and say, I'd like this account to be set up as a payable on death to whoever the beneficiary you would like to be. When you pass away, that beneficiary takes the death certificate to the bank and they transfer the account to her. Again, no probate is needed. Investment accounts, even some vehicles can also be set up in a similar way with what's called a TOD or a transfer on death. But here's the big thing with all these beneficiary designations, that they need to be current and valid. If your mother named her ex-husband from 20 years ago as a beneficiary and never updated after the divorce, then you've probably got an issue on your hands if the intention now is that the money should go to a child. Reason number 3 that you may not need probate is if everything was in a trust. So some people will do more advanced estate planning and create what's called a living trust or a revocable trust. If your loved one set up a trust and actually put their property into it, which is the important part, then when they pass away, the property in the trust doesn't go through probate. This is essentially how it works in simple terms. When someone creates a trust, they're basically creating like a legal container for their property. They put their house into the trust by changing their deed. They put their bank accounts in the trust by retitling them. They put their investments accounts into the trust. And then they name somebody called a trustee to manage everything if something happens to them. So when the person who set up the trust passes away, the trustee follows the instructions in the trust document, and they distribute the property to whoever's supposed to get it according to the trust terms. The court doesn't need to be involved, and therefore there's no probate. When it comes to trust, this is often where I see a big mistake. The trust only works for property that was actually put into it before the person died. So it's not uncommon for someone to take the important step of creating a trust, but they never get around to actually retitling their house or bank accounts into the trust name. In that situation, all those assets that are still outside of the trust still need to go through probate. So if your loved one had a trust, you just need to check whether or not the property was actually transferred into it. When they are properly funded, they're an excellent way to avoid probate completely. As always, I recommend you speak with an attorney that specializes in estate planning to get this set up correctly. If you already have a trust, check in with your attorney to ensure everything is still accurate or if any changes need to get made. Reason number 4, the estate is small enough for the simplified process in North Carolina. If someone dies and the total value of their personal property that would normally require probate is $20,000 or less, or $30,000 or less if there's a surviving spouse as the only heir, you can file what's called a simple affidavit instead of going through full probate. This affidavit basically is a sworn statement where you tell the court, here's what the deceased owned, here's what it's worth, and I'm entitled to collect it. You still file that form with the clerk of the Superior Court in the county where they lived. The clerk will review it. If everything looks good, you get permission to collect those assets. And this process usually takes weeks instead of months. There's less paperwork, lower costs. It's much simpler than full probate administration. And it's a great option where there's a smaller estate where there's not a lot or no property and there's no disputes about who gets what. Keep in mind when you are doing your math to determine if the estate qualifies, remember to include only the personal property that was in their name alone. So bank accounts, investment accounts, vehicles, personal belongings that were only in their name. You don't want to count real estate, life insurance with the beneficiary, or jointly owned accounts. We're just counting the things that were solely theirs. Reason number 5, there's nothing left that needs probate. And this is a final scenario where probate isn't necessary, and it's actually the ideal situation. Sometimes when you look at everything that the decedent owned, you realize that everything transfers outside of probate. A quick example would be if your mother lived here in Wilmington, North Carolina. She owned her home jointly with her husband, who's still living, with right of survivorship. She had a checking account worth $30,000 that was set up as a POD to you, and a 401k that was $60,000 that named you and your sister as the beneficiaries. She had a life insurance policy for $100K that both you and your sister were beneficiaries of, and her car was paid off. If you add all that up, it's about $190,000 in assets, but it still doesn't require probate because everything automatically goes, the house automatically goes to her husband. The bank account, 401k, and life insurance go to the named beneficiaries, and even the car can transfer using a simpler process as long as it's under a certain value. So there's nothing that needs probate because everything has somewhere to go automatically. In this situation, some people still choose to file the will with the clerk's office just to create a public record. All right, so let's quickly recap the 5 reasons you don't need probate in North Carolina. Number 1, the property was owned jointly with right of survivorship. Number 2, there are beneficiaries that were named on all the accounts. Number 3, everything was in a trust and that trust was properly funded. Number 4, the estate is small enough to use the simplified affidavit process under $20,000 or $30,000 thresholds. And number 5 is there's nothing left that requires probate because everything transfers automatically. If your situation matches any of these, you may be able to avoid probate entirely or use a much simpler process. If you're like most people and you're not quite sure, give me a call. I'd be happy to help you find the answer. I've got several other videos that might help your specific situation, so please make sure you're subscribed so you don't miss any of those. Thank you for watching, and I'll see you in the next video.